This is the judgment.
For the sake of clarity, I believe the lead file in terms of the directions.
Was upheld by the Supreme Court, paving the way for their swearing in on 13th of September 2022, beginning what was expected to be a full constitutional term under Article 145, Sub-Article 1, and Article 148, Sub-Article 6. That expectation, however, was cut short following the successful impeachment proceedings against His Excellency Gachagua. The process leading to his removal commenced on 1st of October 2024, when Honorable Mwengi Mutuse, the 9th respondent and Member of Parliament for Kibwezi West constituency, we shall refer to him as Hon Mutuse, introduced an impeachment motion pursuant to Article 145 and Article 150 of the Constitution. The motion hereafter cited multiple grounds, including allegations of gross violation of the Constitution, incitement, and undermining government policy. The 11 grounds were as follows. Ground 1, in the High Court, challenging both the legality and constitutionality of the National Assembly's proceedings. These petitions, consolidated with Nairobi petitions, which I had mentioned earlier, were consolidated and are collectively referred to as the Cohort 1 petitions, with petition number E 522 of 2024 designated as the lead file. 56, that was Cohort 1 petitions. Cohort 2 petitions, where these petitions belong, the lead file is 565 of 2024. On 8th of October 2024, the National Assembly passed the impeachment motion. Subsequently, the resolution was transmitted to the Senate. As the impeachment process unfolded, further applications were seeking conservatory release were filed in the High Court to restrain the Senate from proceeding with impeachment hearings. The Senate thereafter conducted its hearings and upheld 5 of the 11 charges against His Excellency Gachagua, as a result of which he effectively ceased to hold office as Deputy President of the Republic of Kenya. The Senate's decision was communicated to the public through a Gazette notice issued on 17th of October 2024. Following the impeachment, His Excellency President Ruto nominated Professor Kithure Kindiki, the second interested party, whom we shall refer to His Excellency Kindiki, to fill the vacancy in the office of the Deputy President. The National Assembly voted in favor of the nomination, and His Excellency Kindiki was sworn into the office on 1st of November 2024. As the Senate proceedings that culminated in the impeachment of His Excellency Gachagua were underway, and while the National Assembly was concurrently addressing the vacancy created in the office of the Deputy President, further petitions were filed in the High Court at Nairobi and Kerugoya, including petition number 565 and several other petitions, being designated with petition number 565 of 2024 being designated as the lead file. Conservatory orders were initially issued restraining the swearing in of His Excellency Kindiki as Deputy President, but those orders were later lifted by this court in its ruling of 31st of October 2024, paving way for the swearing in as earlier stated. Thereafter, the pleadings were amended and cohort 2 petitions proceeded for hearing, culminating in the present judgment. We will now proceed to summarize the parties' pleadings and submissions in the cohort 2 petitions. Summary of pleadings and submissions. His Excellency Gachagua is the first petitioner. His case is as follows. He anchored his case on the further amended petition dated 13th of August 2025, supported by his affidavits deposed to on 18th of October 2024 and 27th of October 2024. Speaking to the deficiencies in the process before the National Assembly, His Excellency Gachagua deposed that the impeachment motion lacked the particularization and specificity required under Article 145, Sub-Article 1 and Standing Order number 64, 1A. He took issue with the lack of credibility in respect of the charges against him in the National Assembly and the Senate. As regards the constitutional imperative of public participation, His Excellency contended that the National Assembly's process was deficient in that the notice was unreasonably short and that it lacked adequate designated venues. It was his case that the exercise was biased, with organizers framing it as meant for invited members of specific parties. He said that the process utilized unverified feedback forms that resulted in fictitious data. In alleging bias exhibited by the Speaker and Deputy Speaker of the National Assembly, His Excellency deposed that they made partisan statements and also failed to recuse themselves despite having conflict of interest as they were signatories to the coalition agreement that formed a substantial part of the evidence. It was his case that the Senate violated Articles 145, Sub-Article 3 to Sub-Article 6 by skipping the appointment of a special committee to investigate the charges against him, thereby denying him a crucial layer of fair hearing. He stated that Senate imposed an unconstitutional 10-day deadline on the plenary proceedings and unlawfully permitted the National Assembly to introduce new evidence by ambush. He was emphatic that the Senate violated his right to a fair hearing and dignity guaranteed under Article 50 and Article 28, respectively, when he was denied an adjournment. In further support of this position, Dr. Daniel Kibuka Gikonyo, a consultant cardiologist and founder of the Karen Hospital, saw an affidavit on 28th of April 2026 to confirm the medical status of His Excellency Gachagua on the day he was scheduled to defend himself before the Senate. Speaking to the key medical events, it was his evidence that on 17th of October 2024, at approximately 3 p.m., His Excellency Gachagua arrived at Current Hospital with severe chest pain. He deposed that given his age and underlying risk factors including hypertension, history of diabetes, stress, he conducted ECGs and blood tests and recommended a 48 to 72-hour admission to enable close monitoring, further evaluation, and appropriate medical management. It was his evidence that he supervised His Excellency Gachagua's care until discharge on 20th of October 2024. Far from the impeachment process, His Excellency Gachagua impugned the subsequent nomination and approval of His Excellency Kindiki. He asserted that the process was rushed and there was no public participation despite the dictates of Articles 10 and 118 of the Constitution. It was his case that the clearance from the Independent Electoral Boundaries Commission, or IEBC, was null and void since the commission lacked commissioners, and as such, the Secretariat was legally incompetent to clear the nominee. Further to the foregoing, it was His Excellency Gachagua's position that His Excellency Kindiki was disqualified under Chapter 6 due to gross human rights violation, including abductions, extrajudicial killings during the Finance Bill protest when he served as Interior Cabinet Secretary. Finally, His Excellency Gachagua averred that His Excellency Kindiki was not a member of the UDA party for the requisite 3 months preceding his nomination, and it was his case that the National Assembly unconstitutionally metamorphosed the process into an election rather than an approval under Article 149, Sub-Article 1. For these reasons, His Excellency Gachagua sought the following reliefs: a declaration that the respondents have contravened the provisions of Articles 10 and 18, Sub-Article 1, Articles 10 and Article 118, Sub-Article 1 of the Constitution by initiating a process leading to the removal from office by impeachment against the petitioner without first putting in place adequate legislative and procedural measures for effective public participation. In particular, the Senate's decision was not informed by any input from public engagement. 2, a declaration do issue that the impeachment motion lacks the particularization and specificity required under Articles 145, Sub-Article 1 of the Constitution and Standing Order 64(1)A of the Standing Orders of the National Assembly, and is thus incapable of invoking the jurisdiction of both the National Assembly and the Senate under Articles 145 and Article 150. 3, a declaration that the resolution passed on 18th of October 2024 by the National Assembly purporting to impeach the petitioner pursuant to the provisions of Articles 145 and 150 and the communication dated 8th of October 2024 by the Clerk of the National Assembly to the Clerk of the Senate titled, in quote, Resolution of the National Assembly on a special motion on the removal from office by impeachment of His Excellency Gachagua, Deputy President of the Republic of Kenya, close quote, are both founded on a process that is inconsistent and in violation of the Constitution of Kenya and are thus both void and invalid. 4th, a declaration that for the purposes of impeachment of the President or Deputy President of the Republic of Kenya, adequate public participation must be undertaken in all the 290 electoral constituencies in Kenya, the diaspora constituency, and the 1,450 electoral wards where the presidential election takes place. 5th, he sought a declaration that the period of 12 days provided under Standing Orders number 64, sub-order 2 and 6 of the Standing Orders of the National Assembly is grossly insufficient time for the National Assembly to facilitate any meaningful and reasonable public participation during the process of impeachment of the President or Deputy President of the Republic of Kenya. Thus, the standing order is unconstitutional insofar as it has the effect of abridging the time for public participation. 6, he sought a declaration that the proceedings before whole house plenary of the Senate of Kenya under Article 145 of the Constitution of Kenya are not limited or time-bound to 10 days, as would be if a special committee is appointed under Article 145, Sub-Article 4A. He also sought in seventh prayer a declaration that the petitioner's right to fair administrative action under Article 47, right to fair hearing under Article 50, sub-Article 1 of the Constitution were violated on account of the petitioner being denied an adjournment occasioned by illness, thus violating his right to appear in person before the Senate of Kenya to be heard and present his case. He also sought a declaration that the National Assembly and the Senate, in their evaluation of the impeachment proceedings before them, failed to properly assess each of the specified grounds and determine if they collectively or individually constitute a gross violation of the Constitution, warranting voting to uphold the impeachment charges against the petitioner. Hence, the resolution of 8th of October 2024 in the National Assembly and the vote upholding the impeachment charges that of the Senate passed on 17th of October 2024 do not meet the threshold for impeachment set out under Article 150 as read with Article 145 of the Constitution. Hence, the same be and are hereby set aside. An order of certiorari to remove into this Honorable Court and quash the decision and or resolution of the National Assembly and the Senate made on 8th of October 2024 and 17th of October 2024 respectively, resolving to remove from office by impeachment His Excellency Gachagua, EGH, Deputy President, Republic of Kenya. At the ninth prayer, the petitioner sought an order of certiorari to bring up into this court to be quashed the resolution of the Senate of Kenya made on 17th of October 2024 to remove from office by impeachment His Excellency Gachagua, EGH, Deputy President, Republic of Kenya, on the grounds expressed in Gazette Notice number 13/400. He also sought at prayer number 11 a declaration does issue that the IEBC could not clear Kithure Kindiki without the involvement or approval of commissioners under Article 88 and Article 250 sub-Article 1 of the Constitution as read with Section 4 and Section 11A of the IEBC Act. The purported clearance was therefore null and void. Further, the overnight clearance violated Article 10 of the Constitution on openness and transparency. At prayer number 12, His Excellency sought a declaration does issue that Kithure Kindiki is disqualified under Article 10 and 72 of the Constitution due to unresolved concerns from his tenure as Cabinet Secretary for the Interior and National Administration, during which Kenya endured gross violation of human rights. He also sought a declaration does issue that the National Assembly violated Articles 124 sub-Article 4 and Article 149 sub-Article 1, Section 6 of the Public Appointments Parliamentary Approval Act, Cap 7F, and Standing Order 45 in the method it adopted to approve Kithure Kindiki's nomination as Deputy President. He also sought a declaration that Kithure Kindiki was illegally appointed and procedurally cleared and unlawfully approved as nominee for Deputy President in violation of Articles 1, Article 10, Article 8, Article 118, Article 124, Article 137, Article 148. At prayer 15, he sought a declaration that the petitioner suffered harm and is therefore entitled to constitutional damages as compensation for the violations against him in terms of general damages, punitive and aggravated damages, security to be specified at the hearing, special damages number 10346 of 2023 for loss of 1, salary, 2, official transport and other prevailing transport policy for 35 months, medical cover and benefits detailed to be supplied, airtime, gratuity, and annual salary for 5 years. He calculated those sums and gave the figures. At prayer number 16, His Excellency sought pension and other benefits under the Retired Benefits Deputy President and Designated State Officers Act, Chapter 197B of the Laws of Kenya, being a monthly pension equal to 80% of the first petitioner's last monthly salary while in office, 2, a lump sum payment on retirement calculated as a sum equal to 1 year's salary paid for each term served in office. 3, 2 saloon vehicles of an engine capacity not exceeding 2,000 cc, which shares. 4, 1 4-wheel drive vehicle of an engine capacity not exceeding 3,000 cc, which shall be replaceable once every 4 years. 5, a fuel allowance equal to 15% of the current monthly salary of the office holder. 6, full medical and hospital cover, providing for local and overseas treatment with a reputable insurance company for the first petitioner, the first petitioner's spouse, and the first petitioner's child who is below 18 years or is under 25 years of age and is undergoing a course of full-time education, and in the case of a female child, is not married or is not cohabiting with any person. 7, 2 drivers. 8, 1 personal assistant. 9, 1 accountant. 10, 1 secretary. 11, 2 housekeepers. 12, 2 senior support staff. 13, 2 cooks. 14, 2 gardeners. 15, 2 cleaners. 16, armed security guards, who shall be provided on the request of the first petitioner. 17, diplomatic passport for the first petitioner and his spouse. And 18, office and office equipment. 19, maintenance expense for the vehicles provided. 20, access to the VIP lounge 2 at all airports within Kenya. He also prayed for cost of this petition and such other reliefs as this court may deem just. In support of his claim, His Excellency Gachagua submitted, or rather in his submissions, he advanced his case further through written submissions dated 7th of October 2025, which were orally highlighted in court by his counsel, Paul Mute Senior Counsel, Elisha Ongoya Senior Counsel, and Mr. Ochiel Dudley, among others. The unifying premise of their submissions was that the impeachment proceedings were not purely political processes insulated from judicial scrutiny. Instead, they constituted constitutionally regulated proceedings subject to the supremacy of the Constitution, the doctrine of legality, and the supervisory jurisdiction of this court under Articles 23, 47, 50, and 165. Overall, they came up with the following issues for course determination. 1, whether National Assembly motion met the constitutional threshold under Article 145. 2, whether the Senate violated Articles 145 sub-Article 3 to 6 by failing to appoint a special committee to investigate the charges. 3, whether the Senate, misled by its misinterpretation of Article 145, rushed the process and denied the petitioner a fair hearing. D, whether there was adequate public participation at both the National Assembly and the Senate. E, whether the speakers of the National Assembly and Senate were biased in reality or in perception. F, whether the overnight clearance and approval of a replacement of Deputy President evidence a predetermined process. G, whether Standing Order number 62 sub order 2 of the National Assembly is valid. And then lastly, what are the available reliefs? The lawyers for His Excellency, the petitioner, Rigathi Gachagua, collectively submitted that while Parliament undeniably possesses the authority to undertake impeachment, such authority is neither absolute nor immune from judicial review when allegations of constitutional violations, irrationality, or procedural impropriety arise. They characterize the proceedings as a politically engineered process disguised as constitutional compliance, submitting that Parliament specifically observed procedural forms while deliberately undermining constitutional substance, thereby necessitating judicial intervention to preserve the rule of law. Leading the charge on the constitutional standards of the process, learned Senior Counsel Elisha Ongoya anchored his arguments on constitutionalism and legitimacy within Kenya's presidential order. he submitted that the Constitution transformed governance from unrestrained political discretion to a system founded on constitutional limitation and accountability, which rendered all exercise of public power, including parliamentary impeachment, subordinate to the Constitution and amenable to judicial scrutiny. Describing the proceedings as an exercise in malicious compliance, he drew parallels to the historical trials of Socrates, Sir Thomas More, and Jesus Christ to demonstrate how processes can appear outwardly lawful while being fundamentally unjust and predetermined. He maintained that constitutional democracy depends on good faith, adherence to fairness, and constitutional morality, not merely technical compliance. In analyzing the text of Article 145 and Article 150, Council noted that the threshold language, gross violation, gross misconduct, and serious reasons prove impeachment is a mechanism reserved strictly for the gravest constitutional transgressions. To that end, Council drew the support from the cases of Mike Sonko, which we have, particulars we have given, Moya and versus Tribunal appointed to investigate the conduct of Justice Martin Moya. We have given citation. He used these cases to argue that grounds must be substantiated by cogent evidence to an intermediate standard higher than a balance of probabilities. Senior Counsel Ngoya further submitted that since impeachment directly interferes with the sovereign will of the electorate expressed through universal suffrage, courts could not abdicate their responsibility by treating it as a purely political immune process. It was his case that the grave consequences of removal brought the matter squarely within the High Court's supervisory jurisdiction, requiring it to interrogate whether Parliament met the heightened constitutional standards. Senior Counsel Paul Mute submitted on the democratic mandate and the political question doctrine. He was emphatic that impeachment in Kenya's presidential system is an extraordinary constitutional remedy of last resort. He distinguished Kenya's architecture from parliamentary systems where executive tenure relies on legislative confidence. It was his case that the deputy president derives direct democratic legitimacy from the electorate through universal suffrage and cannot be removed due to transient political dissatisfaction or partisan convenience. In view of the fact that impeachment effectively overturns the democratic will, it was Senior Counsel's position that the Constitution deliberately imposed strict procedures and substantive safeguards that courts are duty-bound to enforce. Learned Counsel drew support from the decision in Mike Sonko Mbuvi, which we have stated, to restate that the threshold for removal could not be reduced to political expediency. He further called to his aid the Court of Appeal decision in Martin Nyaga Wambora, we have given citation, to argue that judicial review of the proceedings affirmed constitutional supremacy rather than offend the concept of separation of powers. He firmly rejected the respondents' invocation of the political question doctrine, asserting that the Constitution creates no autonomous islands immune from accountability, and he maintained that all constitutional power remains subordinate to the judiciary's review. Learned Counsel Mr. Chiang Dudley submitted on jurisdiction and the mandatory duty to adjudicate. At the outset, he pointed out an alleged internal contradiction in the respondent's case, simultaneously conceding the court's jurisdiction while urging it to abstain from exercising it. He submitted that constitutional adjudication could not be avoided simply because a dispute implicated political institutions or carried political consequences. He took the position that once allegations of procedural impropriety or rights infringements arose, the process ceased to be purely political. Drawing on the United States Supreme Court decision in Cohens versus Virginia, we've given citation, he argued that a court acts just as improperly when it declines constitutionally vested jurisdiction as when it arrogates jurisdiction it does not possess. It was his case that Article 165 imposes a mandatory obligation on the High Court to determine disputes whose constitutional violations are alleged as such, the judiciary would itself violate the Constitution by declining to hear politically sensitive questions. Mr. Ochieng submitted further that separation of powers does not establish institutional immunity and that judicial review ensures Parliament acts within its boundaries. Citing the Supreme Court advisory opinion in the matter of Kenya National Commission on Human Rights, Council concluded that constitutional interpretation in such disputes must be transformative, holistic, and purposive rather than mechanical. In the written submissions, His Excellency Gachagua specifically impugned ground 8 of the charges, noting that it relied on Section 132 of the Penal Code, a provision already declared unconstitutional in Robert Alai versus the Attorney General matter. On the right to a fair hearing, he maintained that the Senate violated his inalienable right by proceeding in his absence due to illness, contrary to Article 50, Sub-Article 2F and Article 25C. He drew support from Karaoke versus Attorney General, where it was argued that denying an adjournment impacting a citizen's constitutional rights warrants careful circumspection. He further submitted that the rushed manner of the proceedings mirrored the predetermined and unjust actions condemned in Olo versus Kisumu County Assembly Service Board and another, rendering the resulting decisions absolute nullities. Submitting on public participation and institutional incapacity, it was His Excellency Gachagua's case that both houses entirely failed the threshold. He referred to the decisions in Mohammed and 6 others versus County Assembly of Wajir and other cases which we have stated. To reinstate that engagement must be substantive, one that allows reasonable time and utilizes satisfactory mechanisms. In addition to the foregoing, His Excellency Gachagua, while drawing support from the Decision Independent Electoral and Boundaries Commission vs. Attorney General 2025, discredited the involvement of the IEBC, arguing that constitutional functions requiring commission approval could not be lawfully discharged by the Secretariat without a properly constituted commission. In their rejoinder submissions, the legal team also spoke to procedural illegality in plenary investigation. It was His Excellency Gachagua's submission that the Senate lacked a lawful resolution to appoint a plenary investigation. They submitted that the word may in Article 145, Sub-Article 3B, regarding the appointment of a special committee is a mandatory obligation, relying on a set of authorities including Sony Holdings versus Registrar of Trademarks and another. They submitted that courts routinely interpret may as mandatory to effectuate legislative intent. Tracing the constitutional drafting history from the Guy and Bomas drafts to the Wako and Harmonas drafts, it was their case that it proved the framers consistently intended for a special committee to investigate charges prior to any plenary vote. In conclusion, His Excellency Gachagua drew inspiration from the Filipino Supreme Court in Sara Duterte versus House of Representatives. We have given a citation to reiterate that impeachment processes remain strictly subject to the Bill of Rights to check grave abuses of discretion. Consequently, they urge the court to utilize its discretion as established in Imanyara and 2 others versus Attorney General to award damages for the constitutional violations to vindicate His Excellency Gachagua's right and deter future legislative infringements.
I will proceed from the second petitioner's case, that is Thomas Kimoto Maingi. Thomas Kimoto Maingi, the second petitioner in the consolidated petitions, filed a petition dated 25th September 2024, before the High Court at Kerugoya. The petitioner described himself as a former member of the National Intelligence Service, NIS, and contended that his constitutional rights had been violated by statements allegedly made by His Excellency Gachagua on 26th of June 2024 concerning the conduct of NIS during the Finance Bill 2024 protests. He averred that, having served in the NIS for over 20 years before retiring in May 2022, he was publicly associated with the intelligence service within his community, and that the remarks by His Excellency Gachagua portrayed NIS officers as incompetent and responsible for the unrest and loss of life witnessed during the protest. He asserted that the remarks exposed him to ridicule, hostility, threats, and psychological distress, forcing him to temporarily leave his home in Kirinyaga County and seek refuge in Embu County out of fear for his safety. Mr. Maingi further contended that the Attorney General, AG, failed in his constitutional duty as the principal legal advisor to government by failing to advise His Excellency Gachagua appropriately regarding the provisions of sections 24, 25, and 26 of the National Security Intelligence Service Act relating to complaints against the NIS. The petitioner alleged violations of Articles 10, 27, 28, 29, and 47 of the Constitution, claiming that the impugned statements amounted to discrimination, infringement of human dignity, psychological torture, and unfair administrative conduct. Consequently, the petitioner sought the following reliefs: that there be a declaration that the constitutional rights of the applicant as provided for under Articles 10, 27, 28, 29, and 47 of the Constitution have been violated by the respondents. B, that the first respondent be ordered to issue an apology to the NIS members and staff for the utterances and or speech made on the 26th of June 2024. C, cost of the petition, and D, any other relief the court may deem. The second petitioner did not, however, file any written submission. The third petitioner's case. Honorable Njeri Maina, the third petitioner in the consolidated petition, filed the petition dated 2nd of October 2024. That was later amended on the 9th of October 2024 before the High Court at Kerugoya. She is the current woman representative in the National Assembly for Kirinyaga County. She stated that she brought the petition on her own behalf and on behalf of the residents of Kirinyaga County, and in public discretion and in public interest, her petition also principally challenged the constitutionality, legality, and procedural propriety of the impeachment proceedings commenced against His Excellency Gachagua. She contended that public participation process undertaken by the National Assembly in relation to the impeachment motion was ineffective, inadequate, and constitutional owing to the short notice periods and inaccessible venues. She took issue with the insufficient dissemination of information, defective response templates, lack of proper facilitation of members of the public, and the alleged failure by Parliament to comply with court orders directing constituency-level public participation. She further asserted that the impeachment process violated Articles 10, 47, 48, 145, and 150 of the Constitution, and challenged the constitutionality of Standing Order number 64-2 of the National Assembly Standing Orders on the basis that it imposed an unconstitutional 7-day timeline for disposal of impeachment proceedings, thereby undermining meaningful public participation. Honorable Maina also questioned the legality of the Senate's decision to conduct the impeachment proceedings in plenary instead of through a special committee under Article 145, Sub-Article 3B of the Constitution, urging that investigation of impeachment charges could only lawfully be undertaken by a select committee of the Senate. In addition, she challenged the legality of the National Assembly as constituted, contending that it failed to comply with the constitutional two-thirds gender principle under Articles 27, 81B, 100 and 261 of the Constitution, and was therefore incapable of lawfully entertaining an impeachment motion. As such, Honorable Maina sought for the following reliefs. A declaration that the modalities put in place by the first respondent in respect of the public participation forums that were scheduled for the 4th October 2024 regarding the special motion fell below the threshold of proper, effective, and meaningful public participation as envisaged under Article 10 of the Constitution. B, a declaration that the modalities put in place by the first respondent in respect of the public participation forums held on 4th and 5th of October 2024 as ordered by this Honorable Court regarding the special motion were in disregard of the Court's orders and fell below the threshold of a proper, effective, and meaningful public participation as envisaged under Article 10 of the Constitution. C, a declaration that the impeachment process as against the first interested party undertaken by the first and the second respondents in view of modalities of public participation forums held on the 4th and 5th October 2024, failing well below the threshold of a proper, effective, and meaningful public participation as envisaged under Article 10 of the Constitution, were unconstitutional and therefore void. D, a declaration that the appointment of a select committee by the Senate under Article 145, 3B of the Constitution is not discretionary in the impeachment of a president or deputy president in light of Article 259 of the Constitution. A declaration that any proceedings in regard to impeachment of the first interested party taken by the second and fourth petition respondents outside the select committee of Senate under Article 145, Sub-Article 3B of the Constitution are unconstitutional and void. F, a declaration that the first respondent is not legally constituted in light of the mandatory provisions of Article 27, 81B, 10261 of the Constitution on the two-thirds gender requirement. G, a declaration that the first respondent as currently constituted cannot entertain and deliberate the special motion for the removal of the first stated party by respondents. H, cost of the suit, and I, any other order or orders that this court may deem just. The third petitioner's submissions. Honorable Maina supplemented her positions by filing written submissions dated 9th of January 2026, and which she further orally highlighted in court. She identified the following issues for determination. 1, whether the public participation exercise conducted by the National Assembly on the 4th of October 2024 met the constitutional threshold under Article 118 of the Constitution. B, whether the yes-no templates deployed by the National Assembly violated constitutional requirements for meaningful public participation. 3, whether the Senate violated Article 118 by not conducting public participation at the Senate stage. 4, whether the Senate violated Article 145, 3B by failing to appoint a special committee of 11 members. 5, whether Standing Order 64-2 prescribing a 12-day impeachment timeline is constitutional. 6, whether the impeachment process violated Article 50 on fair hearing protections. And 7, whether the impeachment proceedings were conducted by impartial officers as required by Article 50, Sub-Article 1 of the Constitution. Honorable Maina submitted that on the 3rd of October 2024. Honorable Justice Mongo, a judge of the High Court sitting at Kariguya, ordered inter alia that public participation be undertaken at the constituency levels so as to accord the public an opportunity to engage and offer their representations. That these orders were duly served and were never appealed, stayed, varied or reviewed, And as such, they remain binding on the respondents, absolutely. Speaking to the obligation to obey court orders, Honorable Maina submitted that such obedience is foundational to the rule of law, as was held in Law Society of Kenya and 3 others versus Inspector General of Police, and 4 others reported in 2024 KEHC KLR. She submitted that this obligation extended even to cases where the person affected by an order believes it to be irregular or void, as was held in Refrigeration and Kitchen Utensils Limited versus Gulab Chand, Popatlal Shah, and others, the civil application number Nairobi 1339 of 1990. She further submitted that proper compliance required reasonable notice, and not the same day or the next day notice. Physical accessibility at constituency level with open, identifiable venues in each of the 290 constituencies, facilitation of engagement, including civic sensitization, information, language diversity, disability access, and hearings as the primary mode, including oral and interactive engagement. Learned Counsel further submitted that the orders were not obeyed, and only 200,000 participants countrywide who made up to 0.4% of the Kenyan population turned up for the exercise. Council decried the one-day notice published on a Saturday, whose contents were vague as they referred to constituency offices without addresses and times. She also pointed out that no hearings were ever organized, no facilitation was provided, and that CDF offices were closed and the MPs absent. Honorable Maina submitted that she became aware of the purported exercise only past midday, and that none of her counterparts within the Kirinyaga County were aware of the exercise. She further submitted that even the citizens who visited the constituency venues found them locked and no officials or staff were inside. It was submitted that the National Assembly faced a binary choice of obeying the Constitution through the court order or preserve Standing Order 64-2, which provided for 7 days deadline. They chose the latter, which Honorable Maina describes as contempt dressed as obedience. That a legislative outcome obtained in defiance of a binding court order cannot stand in a constitutional democracy governed by the rule of law, as discussed by Lord Denning in McFoy versus United States Company Limited, United Africa Company Limited, reported in 1961, 3 All England Reports 1169, where the learned judge held that, I quote, if an act is void, then it is in law nullity. You cannot put something on it and expect it to stay there. It will collapse, end of quote. Honorable Maina also took issue with the yes and no template as constitutional fraud, as the National Assembly deployed a standardized template reducing 7 complex constitutional allegations into binary tick box questions. That citizens were asked whether they supported impeachment on each ground without being supplied with evidentiary material, explanatory memoranda, and His Excellency Gachagua's response, relying on the Supreme Court and British American Tobacco BAT versus Cabinet Secretary for Health 2019, which we'll hereinafter be referring to as the BAT case. She articulated attributes of meaningful participation to include clarity of the subject matter for the public to understand, structures, processes that are clear and simple, opportunity for balanced influence from public, commitment to the process such that views can influence outcomes, and inclusive and effective representation. She also listed integrity and transparency of the process and capacity to engage on the part of public, including sensitization of the subject matter. Honorable Maina admitted that the digital-only, English-only mechanism systematically excluded rural residents, the elderly, persons with disabilities, the non-English speakers, and the non-English speakers. She stated that there were no physical venues for explaining the template or receiving oral views that were only in 10, that there were only 10 pictures of people attached as evidence of attendance for the 5th October exercise, and that they were contained and that they were conflated responses from 4th and 5th October without distinction, obscuring the impact of the court's orders. She identified that the template was not a procedural imperfection, but an endorsement mechanism designed to manufacture numerical support for a predetermined outcome and is therefore constitutionally void. It was her further submission that Article 118 imposes an independent obligation on each House of Parliament to facilitate public participation in its own business, that the Senate is not a subordinate appendage of the National Assembly, as was held in Speaker of Senate versus Attorney General, reported in 2013, where she stated that the Senate's role in impeachment is determinative under Article 145(7), as it performs a quasi-judicial function of the highest constitutional order. She held the position that the Senate could not constitutionally rely on the National Assembly's defective process, particularly where that process was conducted in defiance of court orders, that the Senate was aware of these defects as they were documented, litigated, and judicially acknowledged. Counsel submitted further that in Mwangaza versus Speaker of the Senate 2025, reported in 2025 Kinyalo reports, this court held that Senate must satisfy itself that public participation was adequate and satisfaction requires inquiry, assessment, and independent judgment, but the Senate undertook none. That the Senate conducted no public participation whatsoever, as no notices were issued, no invitations were extended, no hearings were conducted, and no submissions were received, and that this is not a case of inadequate participation, but a case of none at all. It was also her submission that Article 145, Subarticle 3B of the Constitution provides that the Senate may appoint a special committee comprising 11 members of its members to investigate the matter. On that, she submitted that the word may was a grant of power, not a license to bypass the Constitution, and that once the Senate had elected to proceed under Article 145, it must proceed within the architecture prescribed, which includes a special committee. She further stated that under Article 145, Subarticle 6, it provides that the Senate jurisdiction to vote is triggered only if a special committee reports that allegations have been substantiated, and absent a committee report, the gateway to plenary determination was not opened. She also stated that the constitutional function of the special committee was structured investigation, not political debate, receiving, interrogating, and testing evidence, producing a reasoned report, and insulating investigation from the volatility of plenary politics. That Article 145, Subarticle 5 of the Constitution, guaranteed the Deputy President the right to appear and be represented before the special committee, and by bypassing the committee, the Senate extinguished an entire constitutional hearing stage guaranteed to the Deputy President, thus violating the non-derogable right to a fair hearing. Learned Counsel submitted that standing orders confirmed this distinction, as Standing Order 79 on the Deputy President impeachment provided for a special committee, but no alternative. That Standing Order 80 of the Governor's impeachment procedure, impeachment expressly provides two alternatives, that is, a special committee or a plenary investigation. It was then posited that where the drafters intended to permit plenary investigation, they could have said so, and that the omission of the Deputy President must be respected. Learned Counsel drew parallels to Section 33(3)(b of the County Governments Act, which provides that the Senate may appoint a special committee in governor impeachments, and that the courts, including Wambora, have held that this confers discretion, and the Senate has lawfully proceeded in plenary. That those decisions underscore the opposite point, that where law expressly provides alternatives, discretion exists, but where the Constitution provides only one investigative pathway, the discretion does not extend to inventing another. She submitted that by proceeding to plenary determination without appointing a special committee, the Senate acted without jurisdiction, bypassed a constitutionally mandated investigative stage, and extinguished a guaranteed hearing right. She also submitted that Senate had collapsed constitutionally distinct phases into a single political exercise, and the impeachment proceedings were therefore unconstitutional, null, and void ab initio. It was a further submission that Standing Order 64(2) lay at the heart of the constitutional infirmity, as it imposed unreasonable timelines that rendered compliance with the Constitution impossible. Council invoked Article 2(4) of the Constitution, which provides that any law that is inconsistent with the Constitution is void to the extent of the inconsistency. She placed reliance on Orange Democratic Movement Party versus Speaker of the National Assembly, reported in 2024, where this court affirmed that standing orders cannot override the Constitution nor substitute the constitutional requirements of public participation as expounded by the courts. In that light, Parliament's invocation of good faith was faulted, it being argued that Standing Order 64(2) structurally precluded constitutional compliance. She submitted that where standing order made adherence to constitutional obligations impossible, such a standing order is itself unconstitutional. It was further submitted that Standing Order 64(2) embodied a deliberate parliamentary choice to prioritize political expediency over constitutional safeguards. By prescribing rigid timelines, it ensured that once an impeachment motion gained initial traction, the process would be driven to conclusion before public sentiment could evolve, before courts could intervene meaningfully, or before the affected office holder could mount an effective defense. Counsel argued that this was precisely what the Constitution sought to prevent, since impeachment is not a mere vote of no confidence, but a quasi-judicial constitutional process carrying grave consequences. On that basis, it was argued that this court should declare Standing Order 64(2) unconstitutional, null and void, to the extent that it prescribed timelines incompatible with constitutional requirements, and that any impeachment conducted under its terms is tainted with illegality from inception. On the question of whether His Excellency Gachagua was accorded a fair hearing, Honorable Maina submitted that he was hospitalized with chest pains on the eve of the Senate proceedings. Despite medical evidence of incapacity, the Senate proceeded with a hearing and voted, thereby violating the most basic tenet of the fair hearing rule, audi alteram partem, meaning no person shall be condemned unheard. Counsel further argued that the 12 days between service of the motion and the National Assembly vote were constitutionally inadequate, given that Article 50, Subarticle 2(b) guaranteed the right to have sufficient time and facilities to prepare defense. His Excellency Gachagua, it was emphasized, faced 11 complex constitutional allegations, including gross violation of the Constitution, abuse of office, and corruption, for which 12 days was structurally insufficient. As the Supreme Court affirmed in Sonko case, which we referred above, impeachment proceedings attract the protections of Article 50, and where a fair hearing is denied, the process collapses. On the issue of bias and predetermination, learned counsel submitted that both speakers of parliament as presiding officers over the impeachment motion were constitutionally required to maintain impartiality but acted contrary. It was argued that they assumed the role of initiators and proponents of the impeachment, thereby transforming into advocates for the motion rather than neutral arbiters. In particular, Speaker Moses Wetangula of the National Assembly was said to have participated in public statements endorsing the impeachment before presiding over the proceedings. Counsel emphasized that the test for bias is objective, where a reasonable, fair-minded observer would conclude that there exists a real possibility of bias, and submitted that the Speaker's public statements and advocacy for impeachment satisfied this threshold. Where the presiding officer is biased, she argued, the proceedings are fundamentally unfair, and the failure of the speakers to rescue themselves irredeemably tainted the process. For the above reasons, Honorable Maina urged the court to grant the relief sought in her petition. Next is the 4th to 8th petitioners' cases. The 4th to 8th petitioners, the 4th to 8th consolidated petitions, that is Honorable David Munyi Madenge, Peter Gechobi Kamoto, Grace Modoni Mwangi, Clement Muchiri Muriuki, and Edwin Munene Kariuki jointly filed a petition dated 18th of October 2024 before the High Court of Kenya at Kerugoya. They describe themselves as residents and leaders drawn from various constituencies within Kirinyaga County, and stated that they instituted the petition both in their personal capacities on behalf of their residents of their respective constituencies and in the wider public interest. The petitioners herein challenged the constitutionality, legality, and procedural propriety of the impeachment proceedings undertaken against His Excellency Gachagua, together with the subsequent nomination and approval process relating to Honorable Kindiki, relating to His Excellency Kindiki as Deputy President nominee. They contended that the public participation process conducted by the National Assembly on the 4th and 5th October was illusory, inaccessible, and unconstitutional. In particular, they pointed to the issuance of short and ineffective notices, lack of sensitization, inaccessible venues, absence of parliamentary officials at designated constituency sites, closure of the Kirinyaga Central CDF Hall, and the overall failure by both the National Assembly and the Senate to facilitate meaningful participation as required under Articles 10 and 118 of the Constitution. The petitioners further asserted that Senate unlawfully conducted impeachment proceedings in plenary instead of through a special committee under Article 145(3)(b) of the Constitution, and that the rash timelines imposed under Standing Order 64(2) of the National Assembly standing orders were unconstitutional as they curtailed effective public participation and the hearing and the fair hearing rights. They also alleged that the Senate violated His Excellency Gachagua's constitutional allegations. They also alleged that the Senate violated His Excellency Gachagua's non-derogable rights under Article 25(c) and 50 of the Constitution by refusing to adjourn proceedings on the 17th of October 2024, despite his hospitalization and medical emergency, thereby denying him an adequate opportunity to be heard. In addition, the petitioners challenged the legality of the nomination and approval process of His Excellency Kindiki as Deputy President nominee, contending that the process contravened Sections 3 and 6 of the Public Appointments Parliamentary Approval Act, Chapter 7 of the Laws of Kenya, for want of adequate notice and public participation. The petitioners then sought the following prayers. A declaration that the appointment of Professor Kithure Kindiki, the second interested party herein, as Deputy President of the Republic of Kenya is invalid, null and void. B, a declaration that the National Assembly as a distinct organ is required to undertake its own distinct, proper, effective, and meaningful public participation as envisaged under Articles 10 and 118 of the Constitution in regard to the impeachment of a president or a deputy president. C, a declaration that the Senate as a distinct organ was required to undertake on its own distinct, proper, effective, and meaningful public participation as envisaged under Articles 10 and 118 of the Constitution in regard to a resolution from the National Assembly to impeach a president or a deputy president. D, a declaration that the public participation as scheduled by the first and the second respondent on 4th of October regarding the special motion was not a proper and effective and meaningful public participation as envisaged in Articles 10 and 18 of the Constitution. E, a declaration that the extended public participation scheduled by the first and second respondents on 5th October 2024 was in disregard of the court orders issued by the High Court sitting at Kerugoya in constitutional petition number E014 of 2024, Honorable Jane Jerry Maina versus the National Assembly and 4 others, and was not a proper, effective, and meaningful public participation as envisaged under Article 10 of the Constitution. F, a declaration that the impeachment process as against the first interested party was undertaken by the first and second respondents in view of the impugned, improper, ineffective, and meaningful public participation held on the 4th and 5th October was unconstitutional and therefore void. G, a declaration that the failure by the third and the fourth respondents to undertake any public participation at all in regard to the impeachment proceedings in the Senate as against the first interested party renders the whole Senate impeachment process unlawful and void. H, an order of certiorari to bring up into this honorable court and quash the decision and or the resolution by the first and the third respondents made on the 8th of October 2024 and 17th of October 2024, respectively, resolving to remove the first interested party as deputy president of Kenya by impeachment. I, a declaration that there exists no vacancy in the office of the deputy president, allowing the fifth respondent to nominate anyone to fill such vacancy, and that any such nomination is unlawful and void. J, any other order or orders that this court shall deem just and expedient in the circumstances. K, cost of the suit. Next is the 4th to 8th petitioners' submissions. In their submissions led by counsel, Mr. Evans Ogada, together with Mr. George Sakimpa, the 4th to 8th petitioners identify the following issues for court's determination. A, whether the impeachment process complied with Articles 10, 118, 145, and 150 of the Constitution, whether the public participation conducted by the National Assembly and the Senate met the constitutional threshold of being meaningful, adequate, effective, and lawful. C, whether a standing order 64-2 of the National Assembly is unconstitutional for imposing rigid timelines that undermine constitutional safeguards. And D, whether Article 145 and applicable standing orders require that investigation into impeachment charges be conducted exclusively by a special committee of the Senate, not by the Senate sitting in plenary. They submitted that Article 10 binds all state organs, including Parliament, to the national values such as democracy, public participation, the rule of law, accountability, and good governance. That the impeachment process was conducted with severe haste and limited deliberation, undermining transparency, accountability, and public participation. They relied on the Supreme Court decision in speak of the Senate versus AG and another reported in 2013, where it was held that Parliament was not exempt from constitutional discipline. They submitted further that Article 118 required Parliament to conduct business openly and facilitate public participation, and that this was not a formality, but a substantive constitutional obligation. They contended that the National Assembly gave the public less than 48 hours to consider complex, voluminous impeachment charges, which is a manifestly inadequate time frame, that no explanatory notes or responses from the Deputy President were provided, and that in some counties, like Kirinyaga, designated venues were inaccessible. They further asserted that the Senate conducted no independent public participation at all, as it relied on the National Assembly's deficient exercise, which cannot cure the constitutional breach. And they relied on authorities in Law Society of Kenya versus National Assembly of Kenya, 3 others, reported in 2025 KLR, National Assembly and another versus Okoit and 55 others, Civil Appeal number E003 of 2023, consolidated with others. This is the decision of the Court of Appeal. They also relied on the decision of Doctors for Life and and the decision in Legal Advice Center, and 2 others versus County Government of Mombasa. On the unconstitutionality of the National Assembly Standing Order 64-2, Learned Counsel argued that the provision imposes rigid and unreasonable timeline that make meaningful public participation impossible, and that while Article 124 empowered Parliament to make standing orders, such orders are subordinate to the Constitution and cannot defeat constitutional rights, and Article 2.4 voids any law inconsistent with the Constitution. The petitioners urge the court to declare Standing Order number 64-2 unconstitutional. As the matter in which the Senate proceedings were to be undertaken, Council submitted that Article 145.3 provided that the Senate must appoint a special committee to investigate impeachment charges, and that the use of the conjunctive "and" between sub-articles A and B makes the special committee process constitutionally inseparable from the investigative phase. That Articles 145, Sub-Article 4, Sub-Article 5, and Sub-Article 6 refer exclusively to the special committee, and that there is no mention of plenary investigation or under expresso inius exclusio ulterius that excluded all other modes of investigation. The petitioners submitted further that the special committee ensued suppression of investigations and adjudicative functions, preventing bias and predetermination, and the Senate's decision to bypass the special committee and proceed in plenary fused investigation, hearing, and the judgment into a single political process, violating the hierarchical and sequential structure of Article 145. Learned Counsel placed reliance on Martin Nyaga, Wambora, and 3 others was the Speaker of the Senate. This is the Court of Appeal decision, where the Court of Appeal held that the removal of a governor, which mirrors Article 145, is hierarchical and sequential in nature. Counsel argued that the Deputy President was denied a constitutionally prescribed procedural safeguard available to state officers facing removal, thereby violating Article 27 on equality and non-discrimination. They further submitted that Article 50, Sub-Article 1 guarantees the right to a fair hearing, which is expressly protected as non-derogable under Article 25C. Proceeding with impeachment proceedings while the Deputy President was hospitalized and rejecting a reasonable request for adjournment amounted to a gross violation of natural justice. Counsel emphasized that fairness was the unassailable foundation of any removal process. In support, they cited Gachagua versus Speaker, National Assembly, and 3 others, High Court decision, where the High Court reaffirmed that the right to a fair hearing as non-derogable and that any violation renders the process null and void. Counsel concluded by submitting that the Constitution does not permit Parliament to sacrifice legality at the altar of expediency, and urged this court to reaffirm constitutional supremacy and protect the sovereignty of the people of Kenya. The petitioners prayed for declarations and the and that the impeachment process violated Article 10, 118, 145, and 150, a declaration that Standing Order 64-2 is unconstitutional, a declaration that the Senate unlawfully bypassed the special committee, and orders quashing the impeachment resolution. We'll now proceed to the 9th petitioner's case. Sheria Mtaani na Shedrack Wamboi, a public benefit organization, filed the petition dated 18th of October 2024, together with a supporting affidavit sworn by Dorcas Mwai, an advocate of the High Court of Kenya, and a director thereof. The petitioner stated that it is established to assist members of the public in assessing justice, protecting constitutional rights, and promoting the rule of law, constitutionalism, accountability, and good governance. The petition challenged the constitutional and the legal validity of the impeachment proceedings, leading to the removal of His Excellency Gachagua from office as Deputy President, and further questioned the legality of the intended nomination and approval of His Excellency Kindiki as his replacement. It contended that the Senate proceedings conducted on the 17th of October 2024 violated His Excellency Gachagua's constitutional rights under Article 25C, 47, 50, and 45, sub-Article 5 of the Constitution. That the Senate unreasonably declined to adjourn the impeachment proceedings despite being informed that His Excellency Gachagua had fallen ill and had been admitted at Karen Hospital, thereby denying him an opportunity to personally defend himself against the impeachment charges. It was further alleged that the Senate acted in breach of the constitutional requirements of fair hearing, procedural fairness, and natural justice by proceeding with the impeachment in the absence of His Excellency Gachagua, while allowing the proceedings to continue on the basis of strict constitutional timelines. It asserted that although the Constitution contemplated an expeditious impeachment process, the constitutional timelines could not override His Excellency Gachagua's non-derogable right to a fair hearing and adequate opportunity to defend himself. Sheria Mtaani na Shedrack Wamboi further complained that the proceedings before Senate were rushed, insensitive, and conducted in a manner that prioritized speed over substantive justice and constitutional safeguards. Additionally, the 9th petitioner challenged the legality of the subsequent process initiated by His Excellency the President to nominate His Excellency Kindiki as Deputy President under Article 149 of the Constitution. It was contended that the nomination violated Articles 82, 88, and 137 of the Constitution because IIBC was allegedly not properly constituted and therefore incapable of lawful verifying the constitutional qualifications of any nominee to the office of the Deputy President. Sheria Mtaani na Shedrack Wamboi also argued that His Excellency Kindiki's nomination contravened Article 137 of the Constitution on the basis that he remained a serving Cabinet Secretary for Interior and National Administration at the time of his nomination. For these reasons, the organization sought the following prayers. A declaration be and is hereby issued that the rights and fundamental freedoms of the interested party herein, to which his rights and fundamental freedoms under Articles 25, 50, 27, 47, 145 were grossly violated by the third respondent on the 17th of October 2024 for declining to grant him an adjournment on the Senate sitting deliberating on his removal from office by way of impeachment. B, a declaration does hereby issue that the decision by the third respondent to have the interested party removed from office by way of impeachment to the extent that it was done in gross violation of Articles 25, C, 50, 27, 47, and 145.5 of the Constitution was unconstitutional to the extent of its unconstitutionality and null and void ab initio. C, a declaration that any subsequent replacement of the interested party, if at all, to the office of the Deputy President of the Republic of Kenya was unconstitutional and therefore null and void ab initio. D, a judicial review order of certiorari does hereby issue to bring to its court to this court the decision of the third respondent as communicated via Gazette notice dated 17th of October 2024, communicating the removal from office of the Deputy President from the office by way of impeachment. E. A judicial review order of certiorari does hereby issue to bring to this court the decision of the President of the Republic of Kenya nominating His Excellency Kithure, His Excellency Kindiki as Deputy President of the Republic of Kenya for the purpose of quashing and the said appointment, and that the said appointment failed the qualification for the Deputy President as provided for under Article 137(2)(b) and 3 of the Constitution. F. Alternatively, this court be pleased to make a declaration that the appointment of the Deputy President by the President to fill in the vacancy arising from the removal of the interested party from office pursuant to Article 149 of the Constitution must be read together with Article 82 and 88 of the Constitution to give the IEBC its constitutional mandate to approve the name of the nominee as proposed under Article 149 of the Constitution. G. A declaration be made that the approval of Professor Kithure Kindiki or any other person as Deputy President of the Republic of Kenya is subject to Article 82 and 88 and 137 of the Constitution. Costs of the petition be provided, interest on one above at court rate till payment in full, and this court be pleased to make any further and other relief as it may deem fit in the circumstances. In respect of the 9th respondent submissions, led by Counsel Shadrach Wamoy, the 9th respondent identified 3 principal issues for court's determination. A. Whether the nomination of a Deputy President can be legally finalized or approved in the absence of a fully constituted commissioners of the IEBC under Articles 82 and 88 of the Constitution. B. Whether the Senate's refusal to grant His Excellency Gachagua an adjournment due to documented illness during the impeachment proceedings constituted a breach of the rights to a fair hearing and natural justice under Articles 25C, 47 and 50 of the Constitution. And C. Whether the nomination of Honorable Kindiki while serving as a Cabinet Secretary is constitutionally infirm for violating eligibility criteria under Article 148 as read with Article 137. A learned counsel submitted that His Excellency Gachagua fell suddenly ill on the afternoon of the 17th of October 2024 when he was scheduled to defend himself before the Senate, and that the Senate rushed the proceedings and unreasonably declined to adjourn to allow him to recuperate. That the Senate proceeded with ex parte proceedings leading to his removal from office in his absence, which violated Articles 25C, 51, 47, and 145(5). The organization relied on the Supreme Court decision in Kidero and 4 others versus Waititu and 4 others, reported in 2014, which affirmed that fair hearing incorporates the audi alteram partem principle, and also referred to the Court of Appeal in Judicial Service Commission versus Mutapa and another, reported in 2015, KLR, which held that rules of natural justice apply to all bodies exercising judicial, quasi-judicial, or administrative duties. It submitted that Senate has no prescribed time limitation for completing impeachment proceedings, and the rushing was unjustified. It was the organization's submissions that Article 148(1) requires that a person nominated as Deputy President must satisfy the requirements of Article 137 and 137(1)(b) or 137, and that Article 137(1)(b) provides that a person is not eligible for nomination as President and by extension Deputy President if they hold any other state office, and that Article 260 defines state officer to include a Cabinet Secretary. It submitted that at the time of his nomination and parliamentary approval on 18th of October 2024, His Excellency Kindiki was serving as the Cabinet Secretary for Interior, and therefore he did not satisfy the constitutional eligibility criteria, rendering his nomination null and void ab initio. It was the organization's further submission that at the material time in October 2024, The IEBC was not fully constituted and it lacked the requisite number of commissioners as the previous commissioners had resigned or retired. Articles 82 and 88 establishes a constitutional architecture requiring a lawful and fully constituted IEBC to oversee electoral and nomination processes, and that the Supreme Court in IEBC versus AG Advisory Opinion number 4 of 2024, reported in 2025, held that a clear distinction must be drawn between administrative continuity by the Secretariat and the exercise of constitutional authority vested in the Commission as a collegial entity. It submitted that the exercise of constitutional functions reserved for the Commission under Article 88, Sub-Article 4, cannot be lawfully discharged in the absence of a properly constituted Commission with the requisite quorum. It was further submitted that in the absence of commissioners, IEBC was constitutionally incapable from undertaking its mandated electoral processes, and that the approval of a deputy president nominee, the second highest constitutional office, is no less a substantive constitutional responsibility than delimitation of boundaries, and the same principle applies with equal force. The organization at this court to apply Article 10 on the national values and principle of governance that brings all state organs, Article 20, Sub-Article 3b in the Dubia Pro Libertate doctrine, that where in doubt, the court ought to adopt the interpretation that most favors enforcement of a right or freedom enunciated in Jacqueline Okuta and another versus AG, High Court reported in 2017, and that it further submitted that the unconstitutional exercise of a legislative mandate cannot be shielded from judicial scrutiny, as was held in Commission for Implementation of Constitution versus National Assembly of Kenya and two others, 2013, KLR reported. In the end, the petitioner prayed that the petition be accordingly allowed. I now proceed to the 10th to 41st petitioner's case. That's yours. That's yours. Proceed.
Let me take the 10th to 41st petitioner's case. The 10th to 41st petitioners are a group of Kenyan citizens and one registered association, primarily from Central Kenya region. They filed the petition dated the 17th of October 2024. That was amended on the 18th of June 2025 and re-amended on the 16th of December 2025. They challenged the constitutional validity of the impeachment process and subsequent removal of H.E. Gachagua as Deputy President of Kenya, stating that the National Assembly and the Senate failed to comply with Article 152 of the Constitution, which requires them to modify the presidential impeachment procedure under Articles 144 and 145 for the Deputy President. They said that instead they applied the same rules under Standing Order 64 and 65 for the National Assembly and Standing Order 78 and 79 for the Senate without necessary modifications, ignoring that the Deputy President does not have the same powers, prestige, or legal immunities as the President. The petitioners aver that this failure rendered the entire impeachment process invalid, null and void ab initio, and violated the right to a fair hearing under Articles 25, 27, and 50. It was their further position that the impeachment was not a genuine parliamentary process, but was engineered, sponsored, and bulldozed by political and financial inducements to capture Parliament, turning it into a tool to remove the DP and settle political scores, thereby subverting the sovereign will of the people who elected the Deputy President in the August 2022 general election. They asserted that the president and the deputy president were elected on a joint ticket and that the impeachment violated the rights of the petitioners and other voters from the Central Kenya region who voted for that joint mandate. The petitioners also highlighted and incorporated arguments from Nairobi High Court Constitutional Petition 356 of 2024. In that matter, it was alleged that both H.E. President Ruto and H.E. Gachagua had violated their oaths of office and the Constitution through various actions. Specifically, it was claimed that the president accepted foreign gifts valued at approximately Kenya shillings 240 million in the form of paid-for jet hire and fuel costs for a state visit to the United States, thereby exceeding the legal threshold permitted for such gifts. It was further alleged that the president entered into a secretive treaty with the United States to designate Kenya as a non-NATO ally without tabling the agreement before the National Assembly and Senate as required by constitutional oversight. Additional claims included intimidation and threats directed at members of parliament to bypass oversight, as well as inducement of political defections to artificially control the majority party coalition. The petitioners accused the president of using state violence to criminalize and suppress the Gen Z, otherwise read the Generation X good governance protests, as well as the July 2023 protests against oppressive taxation and the high cost of living, and that he distributed state appointments along acute ethnic lines. Additionally, H.E. Gachagua was faulted for publicly dividing Kenyan citizens into shareholders and non-shareholders in quotes, based on political alignments, whereas H.E. President Ruto is accused of spending hundreds of millions of public funds to conduct avoidable by-elections caused by appointing sitting MPs and senators to the cabinet. The petitioners further argued that the Kenya Kwanza Coalition Agreement binds H.E. President Ruto to nominate a replacement deputy president from the Gikoyo, Embu, or Meru communities, which is the same region as the impeached deputy president. They sought a declaration that the president's power to nominate a new deputy president was subject to certification by the IEBC, that the nominee meets qualifications under Articles 99 and 137, stating that the 14-day and 60-day timelines in Article 149 were meant to ensure public participation across all 90 constituencies. Consequently, the petitioners asked the court to declare the nomination and approval of H.E. Kindiki as the new deputy president as unlawful, null, and void. The petitioners thus sought the following reliefs from this court. 1, a declaration be issued to declare that the first petitioner was impeached by the National Assembly and removed by the Senate under a procedure that violated Articles 27, 50, and 150 sub-Article 2 of the Constitution. 2, a declaration be issued to declare that the first and second respondents have violated the rights of the petitioners and other voters and residents of Central Kenya region by failing to govern together in accordance with their joint mandate secured during the presidential election held on the 9th of August 2022. 3, a declaration be issued to declare that the first petitioner was impeached by the Parliament under the respective standing orders of the National Assembly and the Senate that offends Article 150 sub-Article 2 of the Constitution. 4, a declaration be issued to declare that the impeachment of the first petitioner was null and void ab initio on account of the violation of Articles 25, 27, and 50 of the Constitution, read together with Articles 144, 145, and 150 of the Constitution. 5, a declaration be issued to declare that the second and third to 14th respondents have conspired and schemed to remove the second respondent from office through impeachment in violation of Articles 1, 27, and 38 of the Constitution. 6, a declaration be issued to declare that the second respondent violated Articles 110, 118 and 150 of the Constitution in passing a resolution on 8 October 2024 to remove the second respondent from office. 7, an order of certiorari be issued to quash the resolution of the second respondent passed on 8 October 2024 to approve the motion of impeachment of the first petitioner tabled on 1 October 2024 by the 9th respondent. 8, a declaration be issued to declare that the 6th respondent's power under Article 149 of the Constitution to nominate a person to occupy the office of the Deputy President is subject to certification by the Independent Electoral and Boundaries Commission under Articles 99 and 137 of the Constitution. 9, a declaration be issued to declare that the 14 days period prescribed under Article 149 for the President to nominate a person to occupy the office of Deputy President is to ensure compliance with Articles 10, 38, 99, and 137 of the Constitution. 10, a declaration be issued to declare that the 60 days period prescribed under Article 149(1) of the Constitution for the National Assembly to vote on the President's nomination to fill the vacancy in the office of the Deputy President is to ensure compliance with the requirement of public participation in all the 290 constituencies in accordance with Article 1, 10, 27, 38, 118, and 136 of the Constitution. 11, that by dint of Articles 1, 10, 27, and 38 of the Constitution, the first respondent is bound by the Kenya Kwanza Coalition Agreement dated the 5th of April 2022 to nominate a qualified person from either of the Gikuyu, Embu, and Meru communities to fill the vacancy in the office of the Deputy President occasioned by the impeachment of the second respondent. 12, a declaration be issued to declare that the 6th respondent's nomination and of approval, therefore, by the National Assembly of H.E. Honorable Kithure Kindiki, the second interested party herein, as Deputy President is unlawful, null and void ab initio. 13, the Honorable Court be pleased to issue an order of certiorari to quash the nomination by the National Assembly of Honorable Kithure Kindiki as a Deputy President via Gazette notice published in a special issue of the Kenya Gazette dated 18th October 2024. And 14, a declaration be issued to declare that by dint of Articles 1, 10, 27, 38, 91, and 132 of the Constitution, the citizens of Kenya from the Gikuyu, Embu, and Meru communities have a right secured by the results of the presidential election held on 9th August 2022 to have one of them to occupy the office of the Deputy President during the tenure of the first respondent as the President of Kenya. 15, a declaration be issued to declare that Standing Orders number 64 and 65 of the National Assembly Standing Orders violates Article 152 of the Constitution. 16, an order of certiorari be issued to quash Standing Orders 64 and 65 of the National Assembly Standing Orders to the extent that they apply to the Deputy President. 17, a declaration be issued to declare the Standing Orders number 78 and 79 of the Senate adopted on the 16th of June 2024 violates Article 152 of the Constitution. 18, an order of certiorari be issued to quash Standing Orders number 78 and 79 of the Senate as adopted on 16th June 2024 to the extent that they apply to the Deputy President. 19, an order of mandamus be issued to compel the National Assembly and the Senate, that is the second and fourth respondents herein, to promulgate a procedure for removal of the Deputy President by impeachment envisaged by Article 152 of the Constitution. 20, that a declaration be issued to declare that the first petitioner was impeached through a procedure that amounted to political persecution and vendetta prescribed by Articles 1, 3, 38, and 50 of the Constitution. 21, that a declaration be issued to declare that the sixth respondent engineered, sponsored, and bulldozed the impeachment of the first petitioners in a manner that amounts to abuse of power in violation of Articles 1, 3, 38, 50, and 131(2) of the Constitution. 22, cost of the petition be borne by the first and fifth respondents. The 10th and 41st petitioners' submissions. In these submissions, the petitioners reiterated that the impeachment proceedings did not stem from legitimate constitutional violations. Instead, they arose directly from a severe political fallout and a politics of betrayal, in quotes, between H.E. President Ruto and H.E. Gachagua. They submitted that the impeachment motion was originally assigned to Sirisia MP, Honorable John Waluke, but however, due to his tainted image from a high-profile corruption case, Honorable Mutuse was brought in as a substitute mover to table the motion on the 1st of October 2024. The petitioners listed the following issues for the court's determination. A, whether the impeachment of H.E. Gachagua was a political witch hunt or a genuine procedure. B, whether H.E. Gachagua was impeached by the National Assembly and the Senate under a procedure that violated Articles 27, 50, and 152 of the Constitution. C, whether H.E. Gachagua was lawfully found guilty of Ground 1 of the Articles of Impeachment. D, whether the Standing Orders number 64 and 65 of the National Assembly and Standing Orders number 78 and 79 of the Senate, under which H.E. Gachagua was impeached, violate Article 152 of the Constitution. E, whether the Senate's failure to establish a special committee under Article 145(6) of the Constitution rendered the removal of H.E. Gachagua as null and void ab initio. Issue F, whether H.E. Gachagua was subjected to a lawful and fair trial by the Senate. G, whether the first to 11th respondents conspired or schemed to remove H.E. Gachagua from office in violation of Articles 1, Article 27, and 38 of the Constitution. On the weaponization of impeachment for political settlements, the petitioners maintained that the impeachment was completely manufactured by a political fallout rather than the genuine existence of any lawful grounds under Article 151(b) of the Constitution. That it was fundamentally unconstitutional for the executive and parliament to use the sacred device of impeachment as an administrative tool to resolve purely political disputes and vendetta. They submitted that the impeachment proceedings inside both the National Assembly and the Senate were weaponized and conducted in absolute violation of substantive and procedural provisions guaranteed under the Constitution, as well as the standing orders of both chambers. They specifically maintained that the current rules governing the process, that is, Standing Orders 64 and 65 of the National Assembly and Standing Orders 78 and 79 of the Senate, violate Article 150 sub-Article 2 of the Constitution and must be quashed. placement under Article 149 was strictly subject to certification by IEBC under Articles 99 and 137, and because the 14-day and 16-day constitutional windows under Article 149 are designed to guarantee rigorous public participation across all 290 constituencies, the rushed nomination and approval of H.E. Kindiki was unlawful. It was null and void ab initio. That rushing this process directly violated the political rights of the petitioners under Article 38. A fortiori, the petitioners argued that this court has an obligation to step in and quash the impeachment to halt an ongoing executive scheme to re-establish an imperial presidency in Kenya, and they warned that Parliament has become subservient and sycophantic to the executive, which makes an existential threat, to Kenya's constitutional democracy. Reiterated the prayers that sought to declare the impeachment null, void, and an act of political persecution that Articles 25, 27, 50, and 150 of the Constitution, and orders of certiorari quashing the National Assembly's 8th October 2024 resolution approving the impeachment motion, and Gazette Notice 13401, which appointed H.E. Kindiki as Deputy President. They also sought to quash the National Assembly Standing Orders 64 and 65 and Senate Standing Orders 78 and 79 to the extent that they apply to the removal of a Deputy President and orders to compel both chambers of Parliament to promulgate a legally compliant, constitutionally envisaged procedure for removing a deputy president under Article 150, Sub-Article 2. The petitioners relied on various local authorities, including the Sonko case earlier mentioned, as well as Jirongo versus Soy Developers Limited. They also relied on foreign authorities, including Kriegler versus the Law Society of Alberta, Republic R versus Budry, R versus Campbell, R versus Reagan, all of which citations you will find in the judgment, all from the Supreme Court of Canada. Further reliance was placed on books, articles, speeches, and reports, as well as interview statement by Senator Edwin Sifuna on the Senate floor as per the Hansard of 9th October 2024 and an interview statement by H.E. Gachagua on Inoro TV. In the end, the petitioners prayed that their petition be allowed as prayed. Moving on to the 43rd petitioner's case, Mr. Morara Omoke filed a petition dated 9th October 2024 before the High Court of Kenya at Eldoret, together with a supporting affidavit sworn on the same date in his capacity as a Kenyan citizen and patriot, acting in defense of constitutionalism, the rule of law, and democratic governance. The petition challenged the constitutionality and legality of the impeachment proceedings commenced against H.E. Gachagua by the National Assembly and Senate. He contended that the impeachment process was politically motivated, defective, unconstitutional, and undertaken in violation of the sovereign will of the people expressed during the 2022 general election. His case centered on the alleged violations of Article 1, 10, 38, 47, 48, 50, 73, 75, 94, 118, 145, and 150 of the Constitution, that the impeachment motion tabled by the Honorable Motuse had not been preceded by adequate public participation, and that the MPs who appended their signatures in support of the motion failed to consult their constituents before supporting the impeachment process. He further alleged that the process of collecting signatures in support of the impeachment motion was tainted by bribery, undue influence, intimidation, and forgery of signatures belonging to some MPs. He contended that the subsequent public participation exercise conducted on 4th and 5th October 2024 was merely cosmetic and incapable of constituting meaningful public participation because it was hurried, poorly coordinated, inadequately publicized, and conducted through only one center per county and constituency. He also complained that the public participation forms contained only the allegations against H.E. Gachagua and omitted his responses, thereby condemning him unheard and violating the principles of fairness and natural justice. He also alleged bias and conflict of interest on the part of the Speaker and Deputy Speaker of the National Assembly. He contended that both office holders publicly supported the impeachment process before the motion was tabled and debated in Parliament, thereby compromising their constitutional obligation to act as neutral and impartial arbiters during the proceedings. He asserted that the impeachment motion was politically motivated and arose from internal disputes within the UDA party, yet the parties involved had failed to exhaust internal party dispute resolution mechanisms under the party constitution before initiating impeachment proceedings. He also argued that there existed no comprehensive statutory framework governing impeachment proceedings and the collection of signatures for impeachment motions, thereby rendering the process legally deficient and constitutionally uncertain. Mr. Omoke then sought the following orders. A declaration that the impeachment motion moved by the third respondent does not meet the threshold set out in Article 145 as read with Article 150 of the Constitution. B, a declaration that the impeachment of Geoffrey Rigathi Gachagua was unconstitutional. C, a declaration that the Speaker and Deputy Speaker of the National Assembly were biased and ought to have disqualified themselves from the impeachment process. D, a declaration that the impeachment motion violated the interested parties' rights under Article 32, 33, 38, 47, 48, 50, 73, and 75 of the Constitution of Kenya 2010. E, a declaration that the impeachment motion against the interested party was tabled in a manner that violates Article 110, 94, and 118 of the Constitution, as no public participation was conducted by Honorable Mutuse Ekomas Mwengi and by the members who appended their signatures prior to moving the impeachment motion in the National Assembly. F, a declaration that the impeachment motion, which was a result of a dispute in the United Democratic Alliance Party, was tabled before the National Assembly without exhaustion of internal remedies, contrary to the exhaustion doctrine and Article 159 of the Constitution of Kenya. G, a declaration that in the absence of an enabling legislation operationalizing the provisions of Article 150 of the Constitution of Kenya, there is no legislative and administrative framework within which the impeachment of the DP was anchored, and H, that each party bears its own costs. In his submissions, Mr. Omoke focused on two main issues, namely, whether the impeachment of H.E. Gachagua was unconstitutional and whether the lack of legislation to operationalize Article 150 of the Constitution vitiates the impeachment. He wholly adopted H.E. Gachagua's submissions dated 7th October 2025, submitting that the constitutionality of the impeachment transcends him and must be evaluated with a view to advancing constitutionalism and the rule of law. He maintained that public participation was inadequate and a sham, as the mover of the motion and the 291 MPs who appended their signatures in support of the impeachment motion did not conduct any public participation in their constituencies before signing, contrary to Articles 1, 10, 94, and 118 of the Constitution. That public participation was an afterthought, and when questions arose on 1st October 2024 about whether public participation should be conducted, the Speaker directed that it be held on 4th October 2024. The advertisement appeared on 2nd October 2024, which Mr. Omoke submitted was not a genuine intention to conduct any real public participation from the outset. That the public participation form provided by the National Assembly contained only the allegations against H.E. Gachagua and conveniently left out his response, denying the public the ability to effectively weigh the grossness of the alleged violations. He submitted that public hearings occurred for only 9 hours from 8 a.m. to 5 p.m. on a normal workday, which was a Friday, meaning most Kenyans could not attend. That venues were changed on the eve of the exercise. For example, in Embu, it changed from IFAD Hall to Talent Academy, and in Nairobi, it changed from KICC to Bomas of Kenya. He submitted that in Kiambu constituency, only about 2,000 people attended in a county with over 1 million registered voters, that there was no proper coordination, and he described the situation as utter pandemonium akin to the Tower of Babel. He contended that in some areas, especially in Mount Kenya, public participation forms were faulty. There were incidents of pre-filled forms, and a vehicle ferrying pre-filled forms was torched in Nyeri County. That the National Assembly extended the exercise to the following day on the 5th of October 2024, but no proper notification was made and MPs kept away from the exercise. He added that in some constituencies like West Mugirango, the MP never opened the constituency office, and that the one center per county and one center per constituency is too deficient, as public participation should have been conducted at least at each polling station or at minimum each ward. Mr. Omoke submitted that the National Assembly neither nor considered the feedback collected, and the entire exercise was a mere sham to hoodwink innocent Kenyans. He accused Deputy Speaker Gladys Bose-Sholei of being biased in that on 23rd September 2024, while speaking at a function in Uasin Gishu County, she swore to spearhead the impeachment motion and put the Deputy President on notice, stating in quotes, "Mimi mwenyewe nitakupeleka nyumbani." In brackets, "I will personally take you home." That she also hinted at some of the grounds of impeachment before the motion was even tabled. He further argued that Speaker Moses Masika Wetangula on 29 September 2024, while attending a church function at Wamonyo Catholic Church in Machakos County, publicly took a stand on the impeachment motion before it was tabled. Using the biblical description in Mark 9:38-50, he stated that H.E. Gachagua, being a part of the body that leads to sin, should be cut off. These utterances he submitted violated Articles 47, 50, and 150 of the Constitution, and that neither the Speaker nor the Deputy Speaker should have presided over the impeachment motion. Mr. Omoke submitted that the Constitution sets a high threshold for impeachment as a measure is a grossness of alleged violations, and that grudges and squabbles cannot be the basis for removal. He contended that extraneous grounds were introduced on the floor on 8 October 2024, as it was alleged that H.E. Gachagua had referred to Honorable Florence Jemataya Sergon, the countrywoman rep of Baringo, as a harlot. That Honorable Karoli Omondi, MP Suba North, referred to conversations he had with H.E. Gachagua without providing any proof. Honorable Patrick Makau, MP Mavoko, also made references to conversations without providing any proof. On the vote that 281 MPs supported the motion, 44 opposed, and there was one absentee, Mr. Omoke submitted that MPs abdicated their obligation to weigh the grounds against the intermediate standard of proof set by the Supreme Court in Odinga and 5 others versus IEBC, BC, and 3 others. That the impeachment overturned the decision of 7,176,141 Kenyans who voted for the joint ticket on 9th August 2022, a decision upheld by the Supreme Court, and that the motion was an egregious overthrow of the decision of the majority with that of a few. It was Mr. Omoke's further submission that no statutory legislation exists on the process of impeachment of the President and Deputy President from start to completion, as no legal framework exists on the collection of signatures in support of an impeachment motion. Therefore, there is no framework upon which the impeachment of the Deputy President was anchored. He submitted that in D and others, that is the Attorney General, this court was persuaded by Mr. Omoke, who was a petitioner therein, that the lack of legislation on signature collection and verification and on the conduct of referenda initiated the BBI process. He submitted that the same principle applies here, and that legislation is so central to the fairness of the process that the court ought to, at minimum, issue a structural edict requiring enactment of this legislation. He submitted that areas